Okay, so it's my pleasure to introduce our two presenters today, Kendall Pelling and Andrew Mensch. Kendall is the project manager at East Liberty Development. Over the past 14 years, he has led the planning and implementation of a comprehensive residential development strategy for the distressed urban neighborhood of East Liberty. He's an expert in public and nonprofit systems to recycle vacant and abandoned properties and has served on numerous task forces at the local and state levels. Andrew has been a member of, I'm going to get this wrong, Stepanian, thank you, LLP since 2003, and has been a partner since 2009. He has experience in all of the firm's practice areas and focuses on municipal, land development, real estate, construction, corporate, employment, and family law. So thank the both of you for being here. Kendall?
Thank you.
Sure. Well, thank you all for coming on to this webinar. Because the problem of vacant abandoned properties is a critical problem in the Commonwealth, and it's one that has overwhelmed our public systems. Right? There is not one municipality in the Commonwealth that can say that it has a blight under control, if it has a blight problem at all. So this photo, if the animations were working, you would see the center property, which is 705 Chislett Street, with starting in 2007 looking like a normal house, and then between 2007 and 2016 becoming a jungle in the front. And you would see kids next door of adjoining properties, your classic abandoned property that for nearly a decade sat getting more tax delinquent, abandoned, and nobody was doing anything on it. And public agency actually had a first position mortgage on this property, but nothing happened with it until us, as ELDI, as the nonprofit, which is a nonprofit community development corporation, filed for conservatorship, and now has the legal right to take care of the problem and clean up the blight. Right. So this is that's in essence what conservatorship is. It's having a private entity take responsibility for solving a public problem. Right. And that is the main service to the public, because the neighbors to this property bear a great risk to their health and safety and well-being because of the blighted property, and the community as a whole bears a great risk because of these properties. So that is the great goal of conservatorship, is to create a private right of action, essentially, to solve the public problem of blight, where public agencies have been unable to cope with the scale of the problem. So the law itself is well written and clear, right? So there's a lot of text on this slide, and I just figured I needed to help people understand the basics of conservatorship. But really, if you're interested in this, read the law. Right? The law has clear guidance. It's pretty well understood. The essence of it is that a property needs to be eligible for conservatorship, and that is based on its condition. And it has this two-part test and this set of criteria. Right? We won't go over all of them. If you have questions, please ask. But it's got to be vacant, and it's got to have all of these different conditions that justify its blight and negative impact on the community.
Kendall, someone's asking if you could speak up. I could hear you
Sure.
fine, but maybe others, if you could just speak up a little bit.
Sure, I'll try to do that. Okay, so the next slide here, again, the animation's not working, so you see the property once we've been done with it and it's cleaned up. So imagine this property with siding falling off, broken out windows, massive overgrowth in front of it, so you can barely see it from the street, right? So the timeline is this property went from massive overgrowth to cleaned up in less than 9 months, right? Compare that to a tax foreclosure process that in the city of Pittsburgh takes 3 years to deliver clear title. So again, it's solving a public problem with private initiative. So eligible conservators can be any one of these entities. There are priorities given for both the senior non-governmental lien holders and nonprofits. Governmental units have the right to become conservators as well. And individual citizens can be appointed conservator within certain guidelines, meaning that the property is close enough to their current residence or other property. Interested parties have to get notice, right? Because it's a legal action against the property, an in rem action, right? So throughout this, you'll hear me talking about legal terms and efforts. Remember, I'm not a lawyer. I'm a public management professional, right? So we work with our attorney closely, and so the understanding we've gained from this is by actually doing the cases. But the foundational principle of law is that people who have an interest in a property need to have notice on it. So throughout the legal process, there is always notice of hearings and dates and actions so that all of these entities can protect their interests, right? And that is the foundational force of this law, so that when the judge eventually has the power to compromise other people's interests in the property, they have been given the notice and opportunity to come and defend that interest before the court. So there's a pre-filing process that we have to go through on any property, right? From identifying the property and researching it, right? We want to contact any listed owners if they're around, because we would much rather purchase the property outright from the owner than take it through conservatorship, right? It's cleaner, it's easier, it takes less time, right? But when they don't respond, then we start the process of conservatorship, which is ordering the title search, documenting the property, exploring the mortgages and liens, because sometimes there are mortgage and lien holders who can be negotiated with on the front end, developing a plan for the property, and reviewing documents. Right? This is all due diligence before having your attorney file, because there's no reason to spend legal costs on a property until we've clarified that it actually meets the standards of conservatorship. So this is a basic understanding of the legal process, right? We file a petition to be appointed as conservator. We file a lis pendens, that is a notice on the property that there is pending litigation, right? All the interested parties get notice, right? Remember, legal notice is a core bedrock legal principle. And we get a hearing date, hold the hearing, and we present our justification for why we should be appointed conservator or why someone else should be appointed conservator. We have always had ourselves appointed as conservator. And to date, ELDI has been appointed conservator of 8 residential properties and 1 large commercial property that we'll talk about later. And we have multiple cases that are in the process of being filed. So we've done this part of it many times. The further legal steps, these are things that happen after appointment of conservatorship. So once you're appointed conservator, you then have your plan approved for the property. We try to do our initial plan at the time of the hearing to be appointed conservator, so we save ourselves a legal step. So once we have a plan approved, then we can act on that plan to secure the property, take possession of it, clean it up, and start renovations if that's the plan for the property. There is a process to place financing on the property if it's needed, and if the lender needs to have a priority lien position on the property. That also requires a court hearing. Once the work is to a significant level of completion, then we go through a process to file a conservator's lien. And this is where the powers of the conservator in the Act are turned into a lien on the property. So we provide documentation to the court of all our costs and expenses on the property, add on the conservator's fee that is allowed, which is the greater of $2,500 or 20% of the costs, or then at sale 20% of the sale price. And then that lien is filed on the property. And then these next steps we have not actually been through yet ourselves, which is the petition to sell the property free and clear to either a third party or to the conservator, and then the termination of the conservatorship following the judge's order to sell clear. We have terminated conservatorships where we have negotiated amicable deals with the owners of the properties to bring the conservatorship to an end and have our nonprofit take title. For financing conservatorship, This is one of the challenging parts of it because you're taking risk on a property you don't own, right? So at the beginning part, if you see potential sources of funds, pretty much cash and organizational lines of credit have to be used to fund legal costs and other costs associated with preparing for the filing and getting to that filing for conservatorship. If there is a need to place a conservatorship loan, that happens once the conservator's been appointed. And we've done this several times, and the first opportunity for a loan on a conservatorship property is an existing lender who has the priority lien position. Typically, those lenders do not agree to provide the financing, but they have to be given the opportunity first. Other lenders can then be brought in to provide financing, and we petition the court to give that lender a priority lien, so they go into first position, the priority non-governmental lien holder position, or the first priority governmental lien holder position if it's a governmental lien holder. For instance, we got a loan on one building from the Urban Redevelopment Authority of Pittsburgh, so they became the priority governmental lien holder. So the order of court grants the ability to place that priority mortgage lien as a lien on the property. So it's basically a mortgage with a court order attached to it. That lender can then get a title policy. They can get title insurance on that loan, and so that it feels more like a normal loan to a lender. But it still takes a lender who is willing to do something a little outside of the box. And we have had success securing these loans from a couple lenders. The first is the Reinvestment Fund out of Philadelphia, which has made a line of credit to East Liberty Development to undertake multiple conservatorship properties. Also, the Urban Redevelopment Authority of Pittsburgh has made a conservatorship loan to us, and also Dollar Bank has allowed one property out of a 20-unit development to be a conservatorship property, and has become comfortable with placing a mortgage on that. But in every case, the mortgage lender is going to be concerned about the presence of public sector liens, and will typically deduct the value of those public sector liens from the amount they're willing to lend on the property, because public sector liens stay in priority position unless the judge at the end does something otherwise with those liens. So one of the key things I think is important to understand is there's multiple attorneys who will become involved in the conservatorship representing different interested parties. And we have seen the primary attorneys on the other side from the conservator's attorney being the public attorneys, right? So we should expect them to present arguments and questions to ensure that public goals are met and public interests are protected, right? The law has a legislative purpose section that is pretty clear about the public purposes for this law. But I wanted to itemize here what are the public goals that the conservator is working to achieve, and what are those public benefits. So you can see the first goal that I put in highest priority is eliminating blight and hazards. Right? This is the biggest benefit that the community gets from a conservatorship. Right? And it's a major and immediate benefit. Right? Similarly, making sure that the property is appropriately redeveloped, and eliminating those physical and economic harms for the long haul is also a quick result, because conservatorship clears up these properties faster than the public sector can do it. The third, returning properties to tax-paying productive reuse, is a long-term benefit, but is still significant, because in our work with the public agencies on tax foreclosure properties and others, the consistent goal that's been stated has been to get properties back on the tax rolls, back to productive use, right? And that is more important than some of these other public goals. But it's also important, number 4, is minimizing the burden on public agencies, right? Because blight is an overwhelming problem. So we believe that the public sector, and as represented by its attorneys, should look at conservatorship as an extension of the public's effort to clear up that problem, and supporting and allowing conservators to do this work relieves the burden on those public agencies who are tasked with tackling blight. It becomes one less property that a land bank has to deal with, one less property that has to go to tax foreclosure, right? And that's an immediate benefit to the community and an immediate benefit to the public agencies who are overwhelmed with blighted properties. Number 5 is achieving a public purpose, right? So this is a more minor benefit, but it is a community. They are community goals that can be advanced through conservatorship. For instance, we've had properties that we've been able to turn into affordable housing because we got them through conservatorship. And the last of the public interests is recovering delinquent taxes and fees if possible. Right? This is the small amount of money that these properties owe in delinquent taxes. There are cases where this may be $10,000, $20,000, or $30,000, but I rank it at the bottom of the public benefits because it is the smallest benefit to the public. What's it worth to the public to recover $20,000 but still have a property blighted, abandoned, causing trouble, right? It's like a drop in the bucket, the repayment of taxes and liens, versus the tremendous benefit of allowing a conservator to clean up a property, get it back to productive use and back on the tax rolls, and eliminate the greatest health and safety and economic hazard that the neighbors and residents experience. Right? So in the big picture, we believe that the public agencies and their attorneys should look at nonprofit conservators, and in many cases individual conservators, as advancing the public interest, and collaborate with those conservators to be able to move properties efficiently and effective through conservatorship, and ultimately be willing to allow the taxes and fees and liens that the public holds on these properties to be compromised in the furtherance of allowing that property to be restored to productive use. Because if the public sector was left to its own requirements to deal with this property, it would have to spend more resources to take them through tax foreclosure or take them through conservatorship themselves, and they would end up waiving and eliminating those liens, fees, and costs anyway. Right? That's the way the system works in Pittsburgh in tax foreclosure, and those old liens and fees and costs need to be considered as less important than the value of bringing these properties back to productive use. So that's my initial overview, and Val, I'll turn it back to you for the next part.
Okay, great. This is Andrew?
Yes.
Okay. Yeah, I don't think we were having luck trying to get you the slide accessibility, but just let me know to move it along.
I will do that. I'd like to thank Val, and I'd like to thank the Housing Alliance for inviting me to participate in this afternoon's webinar. I presented in Harrisburg back in the fall with Kendall, and it's a pleasure to present with him once again. I am an attorney in Butler, Pennsylvania, as indicated by the slide. I am the solicitor for the Butler County Redevelopment Authority. And in that capacity, since 2010, I have filed 10 different conservatorship actions involving properties here in Butler County. And during that time, there's been a lot that I have learned, and in terms of the application of the law, I think that we've established that the law can be a usable and successful tool in terms of combating blight. And maybe if you could go to the next slide, please. Mm-hmm. The law is governed by the Abandoned and Blighted Property Conservatorship Act, which was enacted in February 2008. And as Kendall touched on, it is a legal framework established by the General Assembly whereby a party in interest, which can be defined as a nonprofit corporation in the case of Kendall's organization, or a resident or business owner within 500 feet of the building, an owner of the building, or a municipality or school district in which the building is located, or a redevelopment authority having jurisdiction, can go into court and ask that a third party, either it could also be the petitioner or another third party, be appointed as the conservator to take possession of that property and to abate whatever blight or nuisance conditions exist with respect to the condition of the property. Prior to conservatorship, there were tools to address these types of properties, but those tools all had their shortcomings. Principally, the tools available were municipal citations, i.e. you can cite the owners and levy fines against the owners for failure to address the blighted condition. If a property got bad enough, a municipality could go in and condemn the property based upon the condition of the property and ultimately demolish that property. And also there was eminent domain available, whereby a party with that authority, be it a redevelopment authority, be it a municipality, could go in and actually condemn the property through the eminent domain process and take title to the property. Each of those means of addressing blight all had their shortcomings, and so when the act was passed back in 2008, it presented a new tool that could be used to address those properties that didn't fit one of the existing tools. And so there was a lot of excitement at that time as to the potential of how this act could be applied. And if you could go to the next slide.
Sure. Also, a couple of people had said if you could speak up a little bit.
Okay.
There is a little bit of background noise on your end, and I think it's muffling you a little bit, but maybe if you speak a little louder, it would help.
I will try. Thank you. Thank you. So with respect to the Butler County actions, as I indicated, we have filed 10 actions here in Butler County, and probably the most exciting group of actions were the actions that we first filed. And so we filed 4 actions back in early 2010. And these actions were just a couple years after the act had been passed, and as far as I know, they were some of the first actions in this state. And in filing those actions, there were real questions as to how the law would be applied, whether it would work, and whether it could be a viable tool in addressing blight. And so the 4 actions that we were filed all involved residential properties located in rural areas of Butler County. And those actions, some of the challenges in filing those actions were, one, because they were the first actions, there was no established precedent as to how the court was going to deal with those actions. So when we filed them, these were the first actions that were being filed from the clerks in the filing office all the way up to the judges. No one had seen this type of action filed before, so we were, in terms of filing the actions, establishing precedent, and we wanted to make sure that we did everything correctly and that we established good precedent. And so there was some lag initially when we filed those actions in terms of the court picking up the actions and knowing what to do with them. Ultimately, we ended up before a judge, and we're pretty grateful here in Butler County for our local judges, and there was one judge in particular to whom all these actions were assigned, and I met with her, and she established informal rules as to how the actions would be filed, informal rules as to form orders, as to form reports, and so we established those kinds of procedures which were very helpful in moving the actions forward. Those actions which were filed in 2010 all terminated, well, 3 of them terminated in 2011, one of them terminated in 2012, and they all resulted in demolition of the structures that were on the subject properties, and they all terminated following a free and clear sale, which is, I think, the one step that Kendall had indicated with respect to his actions that he has not been through. These ones had all been through a free and clear sale, and so the properties were taken out of the ownership of the owner at the time the action was filed and placed into the hands of new ownership, new owners who indicated that they would maintain the property and pay the taxes on the properties, and all of the existing liens with respect to the properties were wiped out at that time. If we could go to the next slide. The challenges with respect to these initial actions were applying new legislation. That's always a very unpredictable type of circumstance. You never know how the courts are going to interpret the legislation or how the law is actually going to work when put into practice. So we had the challenges there. And then we had service of process issues. As Kendall indicated, you need to, under the law, ensure that due process is given with respect to all interested parties, all owners, all lien holders. And so with respect to just owners, you could have different kinds of owners. You could have natural individuals, natural persons owning the property, and sometimes those individuals are dead. So sometimes you have deceased owners. Sometimes you have owners that can't be found. So those are kind of the challenges with natural persons. With respect to corporate owners, you could have corporate owners, corporate entities, and sometimes those corporate entities just exist on paper and they can't be found. So there are service of process issues that have to be dealt with, timing issues, how long is this going to take, when can we get possession under the law, because as I think Kendall would appreciate, when you're a petitioner or you are a conservator, you need to plan accordingly with respect to abating the condition, and sometimes season, sometimes weather plays a role in that, and so you need to be able to chart a course. So timing is important as to, okay, if we file the action today, when can we expect to have possession? When can we expect to actually have the legal authority to go into the property and start working on the property? So timing issues are always important. And the other thing that we learned is sometimes plans for abatement, and the law requires that you have an initial plan going in. Sometimes those plans have to be modified depending upon the conditions that you find with respect to the property. So for instance, we had a property in that initial batch that we had targeted for remediation. Well, when we actually rolled up our sleeves and we had access to the property under the Act and we got in there, we discovered a significant mold problem which made abatement in that particular instance something that was no longer feasible, and so that one was converted to a demolition. If you could go to the next slide. So very briefly, lessons learned with respect to the Butler County actions. One, that it's important to have due diligence and planning with respect to your properties. And then I think Kendall touched on that in terms of getting your title reports, determining what liens are there, where the owners are, who the owners are. Two, length of conservatorship process. Again, that's important to establishing that timeline so that the conservator knows what to expect. Three is funding, which funding is always going to be an issue. I know Kendall has his funding sources with respect to public agencies. There is a lot of grant funding that is available, and sometimes that funding has certain conditions attached, so making sure that whatever you do within the confines of the conservatorship is within the confines of whatever funding source you're using. And I think the most important lesson learned, particularly with these actions that were filed back in 2010, is that conservatorship can be a viable, useful tool for addressing blight, and that it is just another arrow in our quiver when we look at a blighted property that we can potentially use to remediate the condition affecting that property. And so that's everything that I have with respect to the Butler County actions. The second group of actions that I have been involved with are actions in Northumberland County. And in Northumberland County, I was retained as special counsel to assist their solicitor, Vince Ravito, and this is the Northumberland County Housing Authority, to file conservatorship actions with respect to 12 different properties in Cole Township and the city of Shamokin. And those actions were filed in December of 2014, and as we speak, they are still pending. And the actions in Northumberland County really build upon what we had done here in Butler County in terms of, okay, we have the experience, we know this will work, so let's expand it and use our knowledge to address properties in another location or in another county. So if we could go to the next slide. The properties in Northumberland County were properties that had been problem properties for probably, in most instances, at least 20 years, some even longer than that. And of the existing tools, there was not a good tool to address those properties, and they continue to fester within the community and be detrimental to the health and safety of the nearby residents, as well as just general eyesores within the community. And so the Conservatorship Act allowed the Housing Authority to go in and address these properties, and also allowed the authority to move forward when there were issues in locating the property owners. One of the significant things with these properties is that they were all owned by absentee owners, and so what we had talked about before in terms of locating the owners became probably our biggest challenge in this particular action. In these cases, we had an owner who had a local address, but we believed was in New York City. We could not get him served locally. We tried serving by mail in New York City. That ultimately failed, and so we had to go before the court and petition the court for service by publication, which ultimately was successful. And with respect to the slide that you're looking at, this is just some of the photographs of the properties that were addressed. This is a property that's a Cole Township property on Independence Street, and you can see that that is a single-family residence, and that property was torn down, as were all the properties in Northumberland County. If we could go to the next slide. This is also a single-family residence on Cypress Street in Cole Township, again in significant disrepair, and you can see by the after that that one was also torn down, improving the neighborhood. If we could go to the next slide. This is Lynn Street in Cole Township, again another single-family residence, torn down, and we can see that that one's been converted to a side yard. If we could go to the next slide. This is a row house structure here in Cole Township, Chestnut and Bay Street, and you can see the before condition of this property, and this property had obviously been in disrepair for a significant period of time. So we have two before here. If we go to the next slide, we can see the after, and that property's been torn down and the lot has been cleared, improving the overall neighborhood. If we could go to the next slide. This is a property on Mulberry Street in Shamokin, and if you look at the before slide, you can see that we have two single-family residents in really bad condition. And when we talk about how long some of these properties have been in this condition, these are a couple that have probably been in this condition for the better part of 30 years. And you can see by the after slide that those have been torn down. If we go to the next slide, This is another property in Shamokin. You can see again the before and after there, and just what a difference it makes when we get these kind of properties removed. Currently, with respect to the actions in Northumberland County, all of those actions have resulted in implementation of the final plan, and the structures have been removed. The Housing Authority has moved forward with with bid solicitation, and have awarded bids for the purchase of those properties, in most cases by adjoining owners who are going to use those properties as side yards, and all of those awards are subject to court approval. Our next step in the courts is to go into court and file petitions for approval of the free and clear sales, and hopefully the court will approve those sales and then decree ownership to the successful bidders, and these properties will then be transferred to new ownership, free and clear of liens, free and clear of the blighted structures, and hopefully maintained in a blight-free condition into the future. With respect to the conservatorships in Northumberland County, I think one of the challenges that we had, aside from the service issues that I had mentioned, was just educating the courts, because these were the first actions in Northumberland County. The judge that was assigned to these cases was completely new to this whole world of conservatorship, and so part of it was meeting with the judge, reviewing the act, proposing procedures, proposing practices. With respect to some of the forms used here in Butler County, we use the same forms for Northumberland County, and the judge was very open to us using those forms and very open to our suggestions as to the implementation of the act. And moving forward, once the procedures have been established, both here in Butler County and in Northumberland County, then moving forward, that practice or that framework is in place in regard to potential new conservatorship actions down the road. As we look at guidelines and best practices, I think that the first one is to have a plan for the property, and that's something that Kendall touched on. Look at the property, identify the issues with the property, make sure that it meets the criteria for conservatorship. If it can be purchased outright, then that's probably the best course. If it can't be purchased outright, then have a plan for what you are going to do under the Act to remediate the property, and what you intend on doing after the property has been remediated, whether that be a free and clear sale, or the second option would be to assess the conservator's permitted cost as a lien against the property and to terminate the conservatorship. The second best practice is to have funding for the conservatorship. So how are we going to pay for this remediation? Because the important thing to remember is once your entity, be it a public entity, be it a nonprofit, is appointed as conservator, there is some duty there, there is some responsibility to carry forward and abate that blighted condition, whatever that condition may be. There's also obligations under the Act to insure the property, so there's some expense there. So you need to ensure in terms of your due diligence and your planning that you have the ability to fund the conservatorship. And finally is to have a plan for disposition of the property. So what are we going to do once this conservatorship has been implemented, once the property has been demolished, or once it's been remediated? What are we going to do with the property? What's our anticipated next step? Is it going to be a side yard for an adjoining property? Are we going to request bids? Are we going to sell the property? What are we going to do with it? So you really need to chart a course as a potential conservator as to what the plan is in order to ensure a successful conservatorship. And that's all that I have for my portion.
Yep. Okay. Thank you, Andrew. I'd like to turn it back over to Kendall. He will wrap up with his slides, the presentation, and then we will open it up after that for question and answers.
So thanks. One of the beauties of conservatorship is that you can deal with properties that you don't want to tear down. This is the old St. Peter and Paul Church, which was an enormous property that was not tax delinquent because it was tax exempt, owned by a nearly defunct church, and with owners who had no ability to deal with the property and little willingness to part with it. And we can see, if we look right next door, we have a ball field, right? So we have children playing directly next door to this tremendously hazardous structure and facility. Right behind it are occupied houses, and you can see the blown out, overgrown mess of a school building there, right? And the plan for this property, you can see, is a brand new 3-acre public park across the street and Choice Neighborhoods funded housing. So this was a site that was blighted, that had to be dealt with, where demolition was not the option. And the public agencies were steadfastly against using eminent domain, though that tool would have worked here. And so we were left with trying to do a voluntary sale, right? And we finally did get to a sales agreement, but then the owner had a whole set of liens on the property, and the lien holders were not willing to negotiate a solution. So we had to go through the conservatorship process to be able to invest the substantial money it takes to stabilize this property, right? This is not just a little house that just needs a little new roof, right? It has a massive interior space. It was tens of thousands of dollars just to clear out the junk that was left behind, right? But it's also a grand space, as you can see, right? So this rectory here was collapsing, and one of our sources of funds for the ultimate stabilization and restoration is a HUD-funded loan, which meant we needed to go through the historic process. And our local officials were not ready to let this building get torn down, though it needed to be demolished. And then one day, I got a phone call and went out to look at it. And this is my daughter, Rosa, very excited about being there to see the building having fallen down. So then we got permission to tear it down from the State Historic Preservation Office. Here you can see us doing the roof replacement, and with a big boom on site. This is the largest JLG lift in Pennsylvania at the time, removing tall, hazardous items from the property. And here's the church, right, oriented, fronting on this new park. So very complicated conservatorship with lots of other things involved. So there's an interesting question that Winnie asked about insuring properties. And yes, we were able to get insurance on this big, crazy church building, but it's expensive. It's about $1,000 a month just for the insurance. So here's a property, 409 Selma. You can see it's got a truck parked in front of it, stuff growing out of the front. This was owned by a lender who foreclosed on the property, but then they let it sit there and get wet and moldy. And one of our low-income homeowners, whose house we renovated, was right next door. And the foreclosing lender was out of Florida and would not respond to anything. So finally, we had had enough with this building. You can see that they had gone in and tried to cover up the mold, but they still left it unsecured. So we finally went in, filed for conservatorship, and within 6 months of filing, we had the home renovated and used it as relocation housing for one of our Choice Neighborhoods tenants. So dramatically faster than any other solution. And we ended the conservatorship with a voluntary sale from the foreclosing lender, who finally woke up and realized that we were conservators, and we negotiated a low as-is price for the house based on its original condition. So that was a big success. Next, Val, if you could advance. My network connection just went down for some reason. The next slide is a property that, there we go, is a property that was abandoned and tax delinquent, but we needed to do something with it quickly. We didn't have 2 to 3 years to wait because we had signed an agreement with the Housing Authority of the City of Pittsburgh to build them turnkey units, so permanent public housing that we would build on sites in the neighborhood, and we had to do it quickly. So we filed for conservatorship on this property, and you can see that it meets all those standards for blight. The owner was deceased. And we tore it down. Crunch, crunch, crunch. The house was not worth renovating in any sense of the word. And immediately, so we got to a hole in the ground, but a hole in the ground is not that big of a benefit. And we built a new construction 2-unit structure on it, which is now getting finished. And this is the property where we were able to do one master loan that was a $5 million line of credit loan with mortgages on each property through Dollar Bank. And we were able to have this property be built on while it's in conservatorship. And then at the point at which this house is sold to the Housing Authority, we'll be petitioning to the court to approve that sale. But our approved plan for this lot was to tear the building down and to build this new building for sale to the Housing Authority. And we present budgets and timelines and all that. And it's been so the conservatorship has been a great tool for us to be able to deal with problem properties much faster than we would have through the tax foreclosure process, and to therefore eliminate the blight and hazards on the community, and also to provide some critical affordable housing resources that would not otherwise be available. So with that, can open it up to any questions that you guys have on the call.
The conference has been unmuted.
Do we have any questions? Thank you both very much.
Just photocopy and then scan that.
I have a question, Val. This
is
Winnie.
So you don't need the back. Okay.
If you're not speaking, if you want to do *6 to mute yourself and then *7 to unmute.
Okay, so I'm going to photocopy the front and just scan it in and then email that to you at the information. Okay. All right.
Winnie, you had a question?
Hey, ladies,
yeah, I wondered whether if Andrew could talk about how he educated the judge on future cases, like on forms and guidelines, if that was done during the hearings or if he did that separately, and how he managed that.
Were you able to
hear I had a little bit of trouble hearing the question, but I think the question was how we educated the courts or the judges with respect to developing forms and guidelines. And I can tell you with respect to the Butler County actions, I met with the presiding judge informally, and we basically sat down at a conference table in her chambers with the
The conference has been muted.
I'm sorry, I'm just going to unmute Kendall and Andrew because there was too much noise in the background there. Just give me one moment, please. Unmute, okay.
Okay, are we there?
Yes, and I need to get...
Okay, so with respect to Butler County in terms of how we developed the forms and procedures here, I met informally with the presiding judge, and we basically sat down at a conference table in her chambers with the act in front of us, and we went through the act and determined what steps were required and when there would be hearings, and mutually came up with forms that we could utilize in terms of governing how those hearings would be scheduled and what would occur in the procedures by which the hearings would be scheduled and the procedures for introducing evidence at those hearings. And so that's how it happened here in Butler County. with respect to my experience in Northumberland County, there were, and this is probably the case in almost all litigation in these cases, to the extent that they're filed in the courts, they are litigation cases. Judges oftentimes have status conferences, and so we had a status conference in those cases where the attorneys met with the judge in chambers, and we used that opportunity in Northumberland County to work with the judge in, again, establishing those procedures, establishing forms to use relative to his disposition of the various requests. It was helpful in that case, and again, I was only a special counsel. I was working with local counsel, and local counsel had appeared in front of this judge numerous times, and so they had a good rapport, a good working relationship. There was a level of trust established between them, so I wasn't coming in there as an outsider trying to sell this to the judge, but I had the previous knowledge, I had the experience, so working in collaboration with the local solicitor, we were able to develop forms and procedures with the judge there relative to those conservatorships.
Great, thank you.
Thank
I
you.
do see a question. If you could clarify if the boundary for conservatorship is within 500 or 2,000 feet of the blighted property.
Sure,
this person's in Allegheny, and if that makes a difference at all. Thank you.
Sure, I can do that. So in the law, Section 1103, I've got it in front of me right now. It has the first section as definitions, and party in interest is defined as party interest number 3, a resident or business owner within 2,000 feet of the building. And that party in interest carries over into the definitions of who can be the conservator. Right? So I'd say that in Allegheny County it's 2,000 feet. For a nonprofit, it's the municipality in which you operate. Or if you operate countywide, it's the county you operate in.
Looks like there was another question that, Kendall, you had answered online, but I just want to read it just in case others had the same question. Someone had asked if you have to legally contact the owner before filing conservatorship.
And the answer is that there's no legal need to contact the owner before you file. They have to get served with the filing. We try to contact the owner to try to find a voluntary sale option and make sure that it's worth paying the legal expenses to file.
Yeah, the formal obligation to contact the owner arises upon the filing of the petition. And the Act provides that notice be posted on the property and that the notice can also be served by certified mail, return receipt requested, which is a relaxed form of service from typical service under the rules of civil procedure, which would require service by sheriff. So in the best case scenario, the owner would sign for the mail. You would get the green card back in the mail, and that green card would be filed with the court evidencing service. In those circumstances where you don't have a good address or the owner refuses the certified mail, then you may need to utilize the service of the sheriff or other means depending upon the circumstances.
Great. Do we have any other questions? I've muted everyone, but if someone has a question, they could do *7, and that will unmute yourself, and then that individual can ask a question, or feel free to type it below as well on your screen.
Hi, it's Judy Berkman in the Philadelphia area. I'd just like to point out that in Philadelphia County, we too met with the judges in advance, and they issued a local rule called a general court regulation that does not permit these actions be served by certified mail. It requires service of process like any other action, and it requires a special notice, not just that you've been sued and you should answer and get an attorney, but that you might lose your rights to the property, or if you're a lender being served, that you might lose your secured interest. Do I unmute by *6?
Yes.
And that's a key point, that each court in each county does create some process that they want to see these cases go through. One of the things in all our cases we try to do, and our attorney, which has done a great job, is Wayne Cobb Counsel, And we try to have the same judge hear that case all the way through, so that because there's history with each of these cases, from the initial petition through conclusion. So one of the main challenges we have seen is in the timing, is making sure we plan when we need to file for different hearings so that we can get into the court schedule and on that judge's calendar to make sure that the case doesn't drag out.
And that practice is going to vary by county. I know in Allegheny County, the typical practice is that no judge is assigned. So for different matters, you could potentially have different judges. In some counties, cases are assigned to a particular judge from the day it's filed. So the practice is going to vary from county to county. And that's why it's important, even though, in my particular instance, in Butler County, I've developed a knowledge as to how to prosecute these cases. It's important that, as in the case of Northumberland County, I worked with someone local who knew the procedures and could partner with me in terms of presenting the actions to the court.
Any other questions? Star 7 to unmute yourself. Okay, anything else? Well, this seems like it was a perfect timing. I did want to just mention, while we're on the line, that our Homes Within Reach conference this year is coming up. It's our 13th annual. It's going to be December 4th through 6th, again at the Hilton Harrisburg. And there's an opportunity for workshop proposals. Everyone should have received the link, but we're always looking for ideas. And I just wanted to, while I had everyone on the line, that if anyone has anything in particular that you'd like to see a session on in terms of blight or land banking, feel free, if you want to let me know now, or feel free to email me, or let me know if you have a suggestion. We always look forward to putting great workshops together. And as Kendall and Andrew mentioned, they did a great workshop last November, and it was so good that a lot of the most popular ones end up becoming webinars because people want to get more and more information on them. So what I'll do is I'll be sending this PowerPoint and recording out in the next day or so, and I will also include the link for the workshop proposals. The deadline for that is April 17th. Because it does take a few months to get together with the program committee and come up, with the best content, which would make for another great conference again this year. So if anyone has any comments on that, you could star 7 to unmute the line to say anything, or you could be on the lookout for me, and feel free to be in touch with me at any point. And I don't know if Winnie or Cindy has anything to add to. Feel free to chime in. Okay, great. Okay, Kendall or Andrew, anything more to say? This was very helpful, I think, very for everyone to hear this. We appreciate you taking the time.
Yeah, I just encourage everybody that if you are serious about cleaning up blight, to take the initiative and do something about it. And this is one way that you can actually do that. And instead of just paying to clean something up and having no ownership or rights to that property or any ability to recover costs, this gives you the ability to actually recover the costs of solving that public problem. So do it.
All right, great. Well, thank you both so much. And on that note, I want to wish everyone a great weekend. Thank you.
Thanks.
Thank you.
Bye-bye.
Bye-bye.